Welcome to today's continuing legal education course. Before we begin, a few housekeeping notes. Your attendance will be electronically tracked. Please engage with the random prompts throughout the course to receive a certificate. A copy of the slides can be found in the Course Materials tab to your right. Presenter contact details are included for any follow-up questions. Upon conclusion of the session, proceed to the Credit tab to complete a brief evaluation. Your certificate will be available for download in the Credit tab after submitting the evaluation. Thank you for choosing Sprout Ed, the leading provider for continuing education for the next generation. Welcome to Where Do We Go From Here? Promoting DEI in the Legal Profession, brought to you by Sprout Ed, presented by Bakari Sellers, New York Times bestselling author, former South Carolina State Representative, CNN commentator, and attorney at Strom Law Firm. Thank you for joining. Please welcome Bakari Sellers.
Thank you so much for having me today. I want to first of all just say that I'm from the big city of Denmark, South Carolina, where we have 3 whole stoplights and a blinking light. And my mom and dad always say that the 2 most important words in the English language are the words thank you, and they are not nearly said enough. And so before I begin, I want to say thank you to my special guest that we have with us today. All 3 of them are very, very good friends of mine. Many are faces that you have seen on TV screens talking about issues of the day. Today, we actually get to have some very high level conversations about our legal profession, diversity, equity, and inclusion. But I'm joined by none other than Elie Mystal. I'm joined by none other than Dean Jelani Cobb from the Columbia School of Journalism. And of course, my good friend who you see on CNN often, Van Jones. All 3 amazing men in their own right who will add a little spice and a little sauce and a little swag to today's conversation. I want to give a special shout out to Sprout Ed. And the reason I want to give that special shout out is because they are the reason that we're here. They found it not robbery to give us their time. They found it not robbery to give us their expertise. And they're allowing us this space to be better lawyers, particularly Ben Gold, who actually didn't show up today because he just didn't want to hang out in this cloudy weather that we're here in Columbia, South Carolina. Lindsay Lane and Brad Scudder. I got a chance to hang out with both Lindsay and Brad, and personally, I think they're way cooler than Ben, but that's just where we'll start. We won't go any further than that. Sprout Ed is redefining the way legal professionals engage with CLEs, with continuing education. And this production setup we have here in my office at the Strom Law Firm is top notch. They're innovative, relevant, thought-provoking courses on some of the evolving challenges we have, particularly this issue of diversity, equity, and inclusion. And so after you complete today's session, if you find it engaging and helpful and thoughtful, please check out the other courses in their library. I think this is the 49th course they've had this year. They have one more coming up before year's end. And this is very studio quality. We got they brought my guy in from LA by way of Chattanooga in here to help with the tech. And I am the most technologically inept millennial in the country, but we're going to make it through the next hour and 50 minutes or so together. And so DEI is something that's very near and dear to my heart, but I can also tell you DEI is something that is under assault. And as we talk about diversity, equity, and inclusion, we're going to go through this conversation today, understanding the history thereof. This isn't something that just came about over the past 3 or 4 years. We'll talk about its role in different new phases, such as journalism or artificial intelligence and the web, and how it plays a role in all of those things. And then in light of some of the recent rulings that have come down, we'll talk about its future in our professional marketplace, wondering whether or not diversity and equity and inclusion, the history is now dead or it has no future. We'll talk to Elie on both the front end and the back end, and we'll sprinkle in Van and Jelani in the middle. And so I hope you have an enjoyable time for the next hour and some change as we sit here and delve into what I believe to be a valuable part of bringing us together. Understanding, as we say down south, that if you don't have a seat at the table, then you're on the menu. And we have to make sure that table is reflective of all of our communities. We have to make sure our law firms, our legal practices, the things we pursue, and the way we engage each other is reflective of what we want to see in the world. And so that's the table setting that we'll have for today. It should be a fun moment, a fun couple hours. Merry Christmas to everybody. Happy Kwanzaa, happy Hanukkah. And my first guest is none other than Elie Mystal. And I want to bring him on. What's up, man? As you see him pop on the screen right there, he is the nation's justice correspondent, host of its legal podcast, Contempt of Court. He's a New York Times bestseller, Allow Me to Retort, A Black Guy's Guide to the Constitution, published by the New Press. I don't even know if he's still on X or Twitter, but he used to be on X. I know he's on Blue Sky now. I believe he's on Threads. I have no idea. He's fresh off a boat. He just went on vacation. That wasn't a really crude black joke, but he is fresh off of a boat from a cruise that he just went on with his family. He needed it. And the first thing I said is, come on here and help us understand the history and the future. The first block of this we'll spend with Elie for about 20, 25 minutes. We want to talk about the historical nature and how our legal profession has handled the issues of diversity, equity, and inclusion, and what some of the key turning points have been in that history. So welcome, and I'll let you start with that framing.
Hi, Bakari. Thank you so much for having me. And yes, I got on the boat voluntarily, which is big amongst my people. And so I am back and happy to participate in this. Look, when we talk about DEI in the legal profession, there are a lot of dates where you can start the clock. You can start it beginning of the Civil War. You can start it the ratification of the 14th Amendment in 1868. A lot of people like to start it in 1954 with the decision in Brown v. Board of Ed. I like to start it on March 6th, 1961, with the signing of Executive Order 10925 by President John F. Kennedy. When we think about affirmative action, where does that phrase come from? It comes from EO 10925. I just want to read really quickly. The executive order mandated that employers who kind of take government contracts, employers that get taxpayer money, I can't do a great Boston accent, but the quote is, take affirmative action to ensure that applicants are employed and that employees are treated during their employment without regard to their race, creed, color, or national origin. That's the starting point. That's before the passage of the 1964 Civil Rights Act. And what that executive order says is that it's not enough just to not be racist. You have to affirmatively do things to redress the racism in your contracts and institutions that have plagued victims of this country's original sin from its inception, right? But of course, when we're thinking about the legal profession, we're generally not talking about people who have government contracts. We're generally not talking about jobs or institutions that take taxpayer money. We're talking very exclusively, almost exclusively, in the private sphere. And so that's why access to legal education becomes the key to having a more diverse and representative legal profession. It starts in the law schools because there's no law or statute that can force a private law firm to hire a black person. That's just not how it works, right? We can say, Equal Employment Opportunity Commission, you can't be racist towards black people. You can't force them to hire anybody. So all you can do is have a field of potential legal professionals that is diverse and inclusive. And so then when you look at the major affirmative action cases, right, the first one, Regents of California v. Bakke, the other big, in 1974, the other big one, Grutter v. Bollinger in 2003, it's not an accident that these cases are focused on the professional schools. Right, Bakke is focused on medical schools. Bollinger is focused on law school. These are white people who applied to professional schools, didn't get in, and decided that any black person who got in is the person who is really undeserving. The attack on the diversity in legal education comes through the attack on the diversity in law schools. It comes through the attack on diversity in professional schools, because that's how you decrease diversity in the professions overall. If you don't give people the credentials to participate in these professions, then you cut off the ability for these professions to have diverse hiring right at the bud. And that's what we've seen in the legal profession, where so often the profession is choosing between a predominantly white pool of applicants, right? So yeah, there might be one or two black guys here and there, and one or two black women here and there, and one or two black people might get hired at one or two high-profile firms, or and we'll talk about judges later, I'm sure. But the pool is so limited because of the attacks on affirmative action in the schools in the first place.
When you think about the history of the legal profession, let's just go back, because I'm glad you gave us that executive order, because I always think of DEI in practice around 1949 with Briggs v. Elliott. So it's amazing we have these very nuanced begin dates and start dates. But what are some of the exclusionary practices or systemic barriers that come to mind when you think about the history of the legal profession?
Well, again, first of all, black people just couldn't get credentialed, right? Like it was very hard for black people to get into law schools, to get law degrees. People forget it used to be really easy to get into the legal profession, right? Abraham Lincoln famously didn't go to law school. He read on the law, right? He didn't go to law school. You didn't have to have a professional training in order to be a lawyer. And it's kind of weird that you do when you think about it, right? I mean, like, you kind of understand, all right, doctors, you need to know something about, the knee bone connects to the whatever bone, and have some kind of basic before you are allowed to open people up, right? But if you are representing a case, you can really read that. What you need is a library card, really, to at least take the first step.
That does happen a lot. I mean, you have pro se appellants, and there's no bar to justice if you don't have that legal degree.
Exactly. But what we've decided is that to represent others, you have to go to a law school. Those law schools are incredibly expensive and take a lot of time. Law is a 3-year education. I mean, business school, for instance, only 2 years. Journalism school, only 2 years. Law, it's a 3-year education. And then you have to take a highly competitive, very difficult 200 a question multiple choice test at the end of that legal education to prove that you belong in the profession, right? That is a high bar to even get into the profession, and that is, again, the first culling of a more diverse and inclusive group of lawyers, right? The second bar is, obviously, as I said, it's all private employers, right? And law firms, legal institutions really do run on kind of old school, real old boy network reputation, right? Like, I love To Kill a Mockingbird, right? Great book, really good movie. Gregory Peck out there as Atticus Finch. He's, if you think of Gregory Peck and Atticus Finch as like the kind of the face in the Webster's dictionary of lawyer, right? But read that book. What is he doing? He's going around to his neighbors. He's going around to his friends. He's taking clients for a clutch of eggs, right? This is a country lawyer helping out the people in his community, right? How am I going to get a job at Atticus Finch's law firm as a black man? Like, how? And Atticus Finch is a great guy. How am I going to get that job, really, right? Who's giving me eggs in order to represent them in court in Atticus Finch's community, right? Not a lot of people. Maybe Scout, not a lot of people, right? So then who are the lawyers in our community? Because of this high bar, we don't got them. Because of this incredibly high bar to get into the legal profession, because of how expensive it is, right? I'm 46 years old. I'm still paying off my law school debt, right? Because of how expensive it is, not only does that bar the credentialization of so many black or brown would-be lawyers, it also means that the few who do go through and do get that credentialization usually graduate in tons of crushing, crippling debt, which makes it functionally impossible for you to go back into your community and do really good legal representation for a dozen eggs. Right? You can't actually do that. You almost have to take your black skills and apply them for corporate or wealthy clients who can afford your services, because that's the only way you're going to pay back your debts. That's the only way that's going to happen, right? It's very, the people who can do the most kind of in-home, in-community work usually had family money and graduated law school without debt, right? So that's the other kind of huge bar. But then third, since we are doing a legal CLE, I want people to focus in on Regents v. Backey, right? Because that critical first affirmative action case did something real important, right? What the overall ruling was that you affirmative action was legal, and we will talk when I come back about why it's not legal anymore. But we will affirmative action was constitutional, was upheld by the 14th Amendment and the Civil Rights Act, but that in applying affirmative action, you couldn't use quotas, right? The University of California, Davis Medical School had a set aside for every 100 medical school seats, 16 had to be set aside for applicants from historically disadvantaged communities like Black people, Latinos, what have you, right? And the court ruled that this set aside was a quota, and that quota was unconstitutional. So, number one, that's pretty interesting for a bunch of white Supreme Court justices to certainly decide quotas were not good, because quotas historically have always been what white people use when they want to limit non-white participation in anything. It's quotas that say, like, oh, we have enough Jews at the law firm, we don't need any more. It's quotas that say we have enough Mexicans in the country, you're not allowed to come in anymore. It's quotas that says, hey, the New York Times, we've got our 2 Black writers, what are you doing here, Elie? Okay, maybe that's just me, but you get my point, right? Quotas.
I was like, that sounded kind of personal, Elie. That's
Sorry, man. It's the holiday season. I'm in the New Year's mode. But quotas are something that white justices were okay with for most of American history until quotas were being used to uplift races, uplift non-white races, and all of a sudden, oh, quotas, those are clearly unconstitutional, right? So that's the first problem with the ruling. The second problem, right, is that if you were ever going to make a case that quotas were good and legitimate, it would be with the professional schools. If there was ever a reason to have a quota, Black people are 15% of the population. Black people should be, I don't know, around 15% of the doctors. So I have a chance to get a Black doctor who just on straight statistical evidence is going to provide me better care than a white doctor, because when I go into the Black doctor and say, my leg hurts, they're not going to say, that's drug-seeking behavior, Negro, get out of my office, right? They're not going to say, oh, Black people are genetically better to handle pain, so you don't need any medication. That's not going to happen when I have a Black doctor. Similarly, if Black people are about 15% of the population, Black people should be, via quota or set aside or whatever, about 15% of the lawyers, so that I can go into somebody's office and say, like, hey, this cop beat me. And the lawyer doesn't say, I don't know about that. Seems like you were asking for it, son, right? So I can go to a lawyer in my community and say, hey, this is happening to me in my community, and have a chance at having a lawyer who doesn't think that I'm lying. So it's critically important that there is representation in these professional schools, I would argue, more than anywhere else, right? More than, look, I think affirmative action is good and whatever, but like fundamentally, I know it doesn't really change society if X amount of people get into Harvard Business School, but only Y amount of people get into Yale Business School. People will make money however. But when you're talking about these professional schools, if there was ever going to be a reason for a quota, it was in the professional schools, and Backey cut that off basically from the inception of affirmative action. And our entire debate about DEI or affirmative action has been framed around Backey, has been framed around, it's not a quota, it's diversity. It's not a quota, it's inclusion, right? We talk about diversity and inclusion instead of restorative justice, reparations, and the idea that Black people deserve to be able to have a professional service person of their choice. And that is really like that is what contradicts even good faith efforts in the legal profession to open up the aperture.
the 2 questions that tie into each other that I want to ask you. The first is, I want to be clear with people who are watching, but can you define, I guess legally, since this is a legal seminar, what is equity? like help people understand what equity actually is. And the second thing is, we've had this discussion a lot about DEI. We've had this discussion about who benefits from it, but historically we've always understood that the individuals who overarchingly benefited from the rulings of affirmative action, the executive orders, the case law, et cetera, have always been white women. And talk about whether or not that's a one of those red herrings, a falsehood, and how that ties into our discussions going forward.
All right. So first question first. Equity, I go back. This is where you do have to go back to the 14th Amendment. Equity is simply the equal protection of law. The equal protection of law, not the equal outcome of law. Nobody's asking for equal outcomes. What we're asking for is what we're demanding, what we fought a war over, what we thought we won is equal protection of laws. And that's all equity really means, right? So if you have an opportunity to go to a law school, or to find a lawyer or to have your case heard in court, I should get the same opportunity, right? I mean, I like to think about it in terms of, something that people don't think about a lot, jury selection, right? It was legal to exclude Black people from juries because they were Black until like Barack Obama was born. Right? Like it was like you could just say, I'm not gonna have that, that's Black. I'm not gonna do that, right? We're just not gonna have that on the jury, right? And it is still legal today through the use of preemptive challenges to exclude jurors because they're Black, as long as you find some other reason other than saying they're Black, right? Oh, I didn't excuse that Black guy because he was Black. I excused him because I didn't like the cut of his jib. What the hell? Well, it's not right. It's jibs that we're talking about, sir. That could pass muster, especially with these conservatives on the Supreme Court. That could pass muster today, right? So when we talk about equity, it's simply it can be as simple as equal protection of laws, but it can be as expansive of I shouldn't have to sit in front of an all-white jury. Period. Like period. End of story. We know that white people feel that way. Bakari,
just add one.
you can't.
Let me add one legal footnote to that. We just had the execution of a gentleman here in South Carolina, where we sit, not far. And for those people watching, just if they don't believe Elie or want some real life understanding of what it was, he actually was the last person in this country convicted by an all-white jury, and he was sentenced to death. And so we're not talking about something from yesteryear, from 1950s and 60s. We're talking about 99, 2000. Actually, former United States Congressman, actually a friend of mine, Trey Gowdy, was his prosecutor at the time. And he was not able to receive any clemency or anything. And he was just sentenced to death for what was, just to give you a couple of brief facts, he went in with the intention to rob the convenience store. The clerk from the convenience store pulled out a weapon. There was a tussle. The gun went off. He did not enter the store with the gun. The gun went off. The gentleman died, and they convicted him. The last all-white jury in the country, and sentenced him to death just last month. So, Elie, to your point, and you can continue with equity, and then also talking about the historical benefits of affirmative action, diversity, equity, and inclusion.
Right. So to answer that second question, as you pointed out, white women have historically benefited from affirmative action because, remember, when we're talking about affirmative action, what we're really talking about is opening up the aperture of potential considerations to get into a college or a university, right? To all potential factors. That's all we're talking about, right? So instead of just looking at a person's standardized test scores, which, by the way, are incredibly biased because you can pay to do better, right? I paid to do better. I took a course that helped me do better on the SAT. I took a course that helped me do better on the LSAT. I used to teach a course. I would teach other people how to do better on the LSAT if they could afford it. So you can just pay to do better on the standardized tests. So those aren't. Those are biased, and GPA, which with the differences in high school education and opportunity in this world, I don't think I have to tell you about how GPAs can be biased, right? So instead of just looking at those two biased factors and multiplying them out and figuring them out, you can look at all other factors. Now, we know colleges and universities have for a long time looked at a whole bunch of other factors, like whether or not your daddy is rich, or whether or not your daddy and mommy went to the school before you. That's called the legacy, right? Or whether or not you can dunk a basketball, right? I went to a really preppy high school on Long Island, and this
Did you
super
go
prep
on a
school.
Did you go on a basketball scholarship?
I did not go on a basketball scholarship. You know who went on a sports scholarship? The white girl who got in. I outgraded her by quite a few points, but she was really good at field hockey. The white guy who got in was really good at playing the piano. Harvard, that's where I went to college, respects those kind of things. I had really good grades. Turns out I can kind of like standardize test you into a coffin if I have to. So that's how that played out in my high school. But if all affirmative action says is that, hey, we can look at the white girl who plays field hockey really well. We can look at the white boy who plays piano really well, in addition to looking at the kid who has the best SAT score and the best GPA. We can look at all of that, right? So when we talk about taking away affirmative action, what we're really saying is that race is the one thing we can't look at. Daddy Rich, look at it. Good at dunking basketballs, look at it. Race, overcoming potentially a racial strife, overcoming food insecurity, overcoming poverty. No, we can't look at that. That's unconstitutional, right? So yes, white women historically benefited the most from affirmative action because universities trying to have a more diverse environment were putting in white women who had slightly worse grades than white men. Now, today, if you talk to any educator today, they will tell you the people who are benefiting most from affirmative action are white men. Because if you just did it with test scores and GPA, women are killing men coming out of high school. They are dog walking boys coming out of high school in terms of their grades and their standardized test scores. So you have universities that are still trying to keep a 50-50 balance, right? That would be 55-45, 60-40 if they just did it on straight GPA and test scores. So right now, affirmative action is particularly benefiting mediocre men, mediocre boys. So who benefits from a system where we consider all an applicant holistically, when we consider all the things that goes into an application to college or university, as well as when we consider the full class makeup? When we think about it that way, who wins or loses from affirmative action or affirmative action like policies changes as the society and the culture changes. All that we're doing with our current hostility towards affirmative action is specifically trying to keep Black and brown people out of school by taking away one of the factors that they have to deal with, that they have to overcome, that they have to live with, taking that as the single factor out of the equation, and we can look at everything else.
I think we just saw the repercussions of this recently with your alma mater, Harvard's incoming law school class. I think they have one of the smallest numbers of African Americans in recent history. I think they have about 15 incoming. I know that there are some moments throughout history. I'm thinking of Edmund Pettus Bridge. I'm thinking of April 4th of 68 with the assassination of King. I'm thinking of February 8th of 68, the Orangeburg Massacre. I'm thinking about June of 2015, where you had the Charleston Massacre, where 9 people were shot in a church. And I'm thinking of George Floyd, these historical moments which kind of help push the envelope of jurisprudence in one way or another when it comes to DEI or the election of Trump, et cetera. What are some landmark legal cases that shaped DEI? Maybe not these historical moments, but legal cases that shaped DEI efforts just globally and within the legal profession itself, and ones that stand out to you as, we overuse the word critical a lot, but critical for lack of a better term.
Yeah, well, I mean, obviously the big case that I always yell, you can't talk about this without talking about Grutter v. Bollinger, which I mentioned earlier, that was decided in 2003, because Grutter really did three critical things to the DEI debate, right? One, again, it just upheld the idea that affirmative action and DEI was constitutional in the 14th Amendment. Yeah, great, golf claps, right? Two, the University of Michigan Law School in that case was arguing that one of the things that it had to look at was trying to engender a critical mass of non-white applicants, right? That they kind of found through their research and through the practice of affirmative action up until then, that when you only have one or two of underrepresented group, those 1 or 2 students don't do great, right? Because they are cut off. They don't have any community. And I think that a lot of Black and brown people can understand what they're talking about here. We can code switch. We can function in white society, but it's nice when you have a couple other people who you don't have to explain yourself to, right? Who you don't have to justify your existence to, right? And that was a legal argument that the Michigan made in Grutter that was also upheld, and that was huge for kind of shaping how we think about diversity. And once again, it's why we talk about diversity. We talk about this in terms of diversity instead of in terms of redress and restorative justice, because there's an entirely different affirmative action DEI argument that basically flows from y'all stole us, enslaved us, haven't paid us back our back pay that we're owed. So now to redress that fact, you're going to give us an opportunity to have positions and privileges just like the white man. That's an entirely competent, intellectually justifiable argument. That's not the way we've gone. And a lot of that is because of Grutter. It's because of Bollinger, right? Because the court said, don't go that way. Instead, talk about diversity, inclusion, all this stuff, and we'll let it go through for, and this is the third thing that Bollinger did, for 25 years. Sandra Day O'Connor in this 2003 case said, yes, it's constitutionally protected. Yes, it's good. But within 25 years, her words, we should not be in a position where we have to use affirmative action anymore. And to talk about the insanity of that statement, first of all, it is the only case that I am aware of where a Supreme Court justice has pulled an arbitrary timeline out of their ass to tell me about when a constitutional right is supposed to sunset. We don't do that anywhere else. You don't have a Supreme Court case saying like, oh, everybody has the right to an AR-15 now because people like their guns. But, 25 years, there should be no reason for anybody to own an AR-15. We don't do that because the idea that a constitutional right stops working after Sandra Day O'Connor has gotten sick of it or thinks that we're done with it is insane, is just insane, number one. Number two, it shows how the entire debate has been shaped, right? In terms of using affirmative action or DEI as a Band-Aid stopgap measure, essentially, until Black people stop complaining. Not using it until white people stop being racist. If you're going to put a timeline on it, the timeline is, and we will not have these programs once white people get over themselves. And I don't know when that's going to be, but hopefully soon. Right, that would be the timeline, but no. They don't put the timeline on white people getting better. They put the timeline on Black people having gotten enough already. And it's disgusting to me. It's the only Supreme Court case that I can think of where this kind of arbitrary timeline was imposed. And it shaped our entire debate around what affirmative action is, on what DEI is, on how you have to explain your DEI programs, right? So if you think about it this way, the courts for a generation told us that the only way you can have this is if you shaped it around the ideas of diversity, equity, and inclusion. And then all of a sudden, as we get to the end of the 25 years, by the way, all of a sudden, white conservative says, oh, diversity and equity and inclusion, what's that? That's made up. Why are you talking about that? We don't need that. What? We're talking about this because that's what you told us we were allowed to talk about. Sorry, I get angry.
Elie, got you fired up, ready to go. I want you to go sip a little Jameson or whatever you sip on for the next 50 minutes. I'm going to bring you back because I don't know if you're going to leave us with any doom and gloom, but we're going to talk about the future of DEI with you when we come back, definitely post-affirmative action. Thank you so much. We now have our good friend, Elie and I's good friend, none other than Dean Jelani Cobb joining us. Dean Cobb, man, you look handsome. Dean Cobb joined the Columbia Journalism School. Joined the Columbia Journalism School faculty in 2016 and became dean in 2022. He has been a staff writer at The New Yorker, which is, I read his writing often. Since 2015, he received a Peabody Award for his 2020 PBS Frontline film, Whose Vote Counts. And I did not know this until I was preparing for this today. that he was a finalist for the Pulitzer Prize in commentary in 2018. Who beat you for that?
Oh, a friend of mine. So we John Archibald in Alabama, and I joke with him about it every time. I give him a hard time about it every time I see him. So
Yep. Well, thank you. He's also the father of twins. We share that. We're twin dads, and we're
oh,
going
that's
through
right.
it
Yeah.
over this holiday season. So, as dean of the School of Journalism, we're doing this CLE, this legal education course on diversity, equity, and inclusion, and I want to talk about the media and journalism and how that plays a role in kind of where we are in this new field, which is going through its ups and downs. But my first question to you is: there is power in storytelling and advancing social justice, and what are some of the tools lawyers can use, storytelling or through their own means or modes of journalism, to advocate for DEI within their own organizations and communities?
Yeah, so I think that's one of the most powerful, tools that we have, which is narrative. It's an ancient one. Before we had any cultivated form of civilization, we had, the story around the collective fire. And so it's the way that we make sense of the world. And so for us as journalists, our storytelling is constrained, by particular factual, protocols. So in the way that, kind of attorneys have that in common. But I think that there are, both in law and in journalism, there are inert facts. And, there's data and there's information. And what really distinguishes the ability to reach people is how you make those facts cohere into a beginning, middle, and end. When we think about, even, all kind of news papers or news organizations think about this on some level. Tabloid papers just put it kind of out front, but we're all writing about the kind of fundamental human keys, anger, betrayal, the endangered child, the case of a person held in high esteem who has acted dishonorably. These things that evoke kind of fundamental emotions in us, and you work around kind of the narration of that. And so that's one of the things I think is important for people. I'm on this new kick, I should say, that there are lots of professions that need the skills that journalists have, in terms of storytelling, in terms of information gathering. And our objective is for people to recognize the skill set that journalists have as applicable to all these other kinds of areas.
One of the things that I was, as I was going through the questions and we were preparing for today, one of the questions that I was really honed in on asking you is, we've seen a lot of events, particularly since 2020. We've seen different election cycles, et cetera, that go back to 2016. We've had these, earth-shattering events from Charleston to Buffalo, New York, et cetera. But how have these narratives, perpetuated by law and media, shaped the public perceptions of equity and justice? Because it seems like those words of equity and justice have gone on what is a roller coaster. And how have they shaped those?
Yeah, and so one of the fundamental things here, that if you study the kind of history or even give a close look at the kind of contemporary landscape, is that there are these two narratives of equity and justice. And one of the more disturbing things is that when you look at the civil rights movement, we now would say this was a movement that was oriented toward the achievement of equity, the achievement of justice, the achievement of equality, and so on. The more complicated and difficult thing, is, and this is something you likely know well from way before, from growing up, the more difficult thing is that when you look at the rhetoric of the people opposing the civil rights movement, when you look at the rhetoric of people utilizing violence to thwart the civil rights movement, when you look at the rhetoric of the people who assassinated Medgar Evers, who assassinated Dr. King, when you look at the toll of violence, those people use the same language of equity and justice. And so there is this unjustifiable perception that, and this is the kind of dynamic we've seen, on and on and on. This is unjustifiable perception that the pursuit of equality on behalf of people who have been marginalized is actually a pursuit of superiority. And so when, one of the, famous instances of this is that, when you saw that gigantic, filibuster and the difficult effort to get the 64 Civil Rights Act passed, there's an Alabama senator J. Lister Hill, who came to the floor and said that the Constitution does not allow for the provision of special rights to any one community. And people in the civil rights movement would have said, exactly. Yeah, it doesn't. And so, but his argument was that by protecting the civil rights of Black people, you were in fact affording us extra constitutional additional rights. Never mind the fact that we couldn't vote, at risk of our lives. Never mind the fact that we couldn't use public accommodations if we did so at the risk of our lives. Never mind the fact that all these statutes and laws had essentially removed us from civic and social life, but the idea of protecting us from those impositions was itself the granting of an extra constitutional right. And so the language neatly transfers over to the conversation that we have about affirmative action, to the conversations that we have about the protection of voting rights now. Even going back to that 2012 decision, it was essentially a decision that held that white Southerners were being unjustly accused of racism, which is what you can distill John Roberts' logic down to. All of these ideas that begin with the presumption that, in fact, there is an equal playing ground, and any additional benefits that have accrued to the historically enfranchised community are just, take a pick, the result of virtue or hard work or good genes or any other, set of unlikely candidates.
From your journalism perch, one of the things that we're seeing right now is this clash of legal concepts. Right now, you're seeing this clash of diversity, equity, and inclusion versus what is now free speech. And you're seeing these things go at each other. And one is, if you're in the corner of free speech, then you find yourself diametrically opposed to wokeism or DEI. Tell me how you're seeing these two from your perspective, and what your students are learning, how you see those two things clashing. And I'm assuming they can coexist, but maybe you can tell me if I'm wrong.
I mean, they coexist. These kind of ideas coexist in all sorts of ways. It is really a question of whether we see the imperative of finding a path in which they can coexist. As it stands now, we have seen DEI essentially stigmatized. We've seen rhetoric that accuses, the practices of diversifying, bringing, equity and including people in the fold of our institutions as discrimination against the people who have already historically been enfranchised in those institutions. And on the other side of it, the kind of protocols of DEI, for respectful interaction, kind of basic cultural competency and those sorts of things, are often decried as impositions upon free speech. But it took an attorney friend, who pointed this out to me about the wide berth that we have in employment law around what you can and cannot say in the workplace, with the risk of creating a hostile workplace. And that was because we recognize how essential the workplace is to our economy, and that you have to have productive workers and these other kinds of things. What we have failed to do is put that same level of effort into saying, what is the reasonable balance we can find between the maximum free speech, maximum utility of free speech, and the maximum utility of inclusion or Title VI or any other kind of like things that we want to think about. Instead, we've been much more likely to see those things clashing and being framed in a really totalizing view of either all this or all that.
In the journalism profession now, I guess my question, and maybe we can parallel this to the legal profession. How do you make sure, and all of your students aren't going to go out and necessarily just be beat writers. Some of them are actually going to run newsrooms, right? They're going to be editors, etc. So how do you ensure that their efforts around diversity, equity, and inclusion are authentic and not performative?
No, we have these discussions in class, and we kind of toss them into the deep end of the pool. One of the things that it starts at home, literally, in our efforts to make sure that there's a broad representation of people, in the journalism school. On the other side of it, that goes on the classroom side. Who's on the front of the classroom? Who's sitting in the seats in the classroom? Who is the guest? In that classroom. Who are the staff and the various other kinds. We want to make sure that the entire institution represents the society that we live in. On the other side of it, this is wired into our curriculum where we're looking at especially for news organizations, it's not hypothetical. Literally the story you get, is contingent upon the capacity of people to operate in particular communities. And those can be communities based on, professional background. It could be communities based on military background. It could be communities based on ethnicity, religion. Our job is to chronicle the entirety of human affairs. And so you need as many voices and perspectives as possible. So you want the Southern Catholic Latino former military person, the person who understands all of those different things, as many of those people as you can get, because when they're in the conversation is richer. And so we try to demonstrate that by doing it, and also kind of going through that in our classroom about how you, pursue stories and, what kinds of interactions you have with people with different backgrounds. And it goes the other way too, which is that we don't want to create a one-to-one ratio where if there's a story that happens and it happens to be in a predominantly African-American community, they're like, okay, you, Joe, you're Black. We're going to send you out there. We want people to be able to interact across a broad swath of different communities. So one example I'll give you of this is that when, unfortunately, I had to go cover the Tree of Life, massacre, which was the shooting that happened, I believe it was 2018 in Pittsburgh, where I think it was 11 people were killed in a synagogue, and it was an clearly very anti-Semitic attack. And I had been covering a lot of mass shootings at that time, and so that was how it felt to me to hop on a plane and go to Pittsburgh. But before I hopped on that plane, I called a number of my Jewish colleagues and was like, I just want to know, like, the sensitivities, here, this community. I had the good fortune of finding a historian who had written her doctoral dissertation about the very community, the Jewish community where this attack happened. I got her on the phone, talked to her. You did all my background, so I understood how I interacted in this community in a way that had the maximum level of insight and respect and sensitivity. And I think that those things go in both directions. It wasn't any imposition on me to do that. But I was also following the fundamental ethics of DEI. I'm interacting with a community that I'm not familiar with, or I'm somewhat familiar with, but there are lots of nuances and things that I would miss. I want to take advantage of the fact that I have colleagues who know all these things, and I can actually get a sense from them so there are mistakes that can be avoided.
One of the questions that I think you are examining day by day now is with these new kind of attacks on journalism itself, not just DEI, but journalism itself, and probably an eventual attack on Times v. Sullivan. What role does journalism and you and your students play in holding institutions accountable for advancing diversity, equity, and inclusion, particularly in this time? And how has it changed over time?
Yeah, so our accountability function, has evolved, with the country itself. When the press first started and when the country first started, the press was often just kind of like broadsheets that would give you agricultural information or publish scandalous gossip about this person or that person, which is by the way one of the reasons why people didn't believe that Thomas Jefferson had actually impregnated Sally Hemings for so long, because even though this had been a news story, like basically nobody believed the news at that point. The news was very kind of scurrilous at the time. But moving forward, is really in the 20th century that we refine the sensibility with the kind of development and advent of investigative journalism, of the sense of a public having a right to know. My colleague Michael Schützen at the journalism school has written a wonderful book about that, about how we came to have a sense that the government owed certain information to the public, the development of the Freedom of Information Act, all these kinds of things. So that's fundamental to us. It's not coincidental that New York Times v. Sullivan comes out at the same time the civil rights movement. It's a case that involves essentially as a civil rights case, and so that winds up kind of going over into a free speech case. Our ability to chronicle and to cover the most contentious parts of the society and most contentious moments in the society is contingent upon these kinds of protections. And like any protection, it can be abused. And in that instance, you try to find ways that you minimize that, either through professional ethics or through other kinds of mechanisms. But every single right that we have can be abused in some way, shape, or form. We operate with the presumption that upholding those rights, in a net is a net benefit. But we wind up doing more good than harm. And so for us, that's the kind of landscape that we require. And the looming prospect of an attack on New York Times versus Sullivan, lots of other kinds of political and extra political attacks on journalism could create a landscape in which it is much more difficult for us to perform that accountability function. And ultimately, corruption flourishes, ineptitude flourishes, incompetence flourish, like those kinds of things wind up becoming the benefit that none of us, or benefit a handful of people at the expense of a great many.
Yeah. How because this terrain is different. How do we operate? How do legal professionals operate? How do journalism or journalistic professionals operate in this new time where social media, TikTok, IG, Twitter, Facebook, all of these, Snapchat, how is this new landscape affecting that accountability mode, your profession? How are you seeing it affect other professions? And what should legal professionals kind of see as we walk through this?
What's interesting, one of the other things that I think law and journalism, and for that matter, a bunch of other professions have in common, is this declining trust. And I spoke to a group of doctors about 2 years ago. And this group, it's a medical conference, but each year they bring in a person who has nothing to do with the medical field to give a keynote. And I came in and gave my keynote. I talked about trust. I said, everyone has talked about the declining trust in media. And, very few people have talked about the fact that you all have the same problem. And I was like, you all are competing, you have the Surgeon General competing with a YouTuber who is broadcasting from his local McDonald's where he gets free Wi-Fi. Like that person's counterbalancing with you as a source for medical information. And so when you have these professions that have traditionally enjoyed a great deal of the public trust, they sometimes don't know how to react at moments where people don't trust us. So I think we're at a moment, and especially because there are all these alternative voices with misinformation and disinformation, I think we're at a moment where it's imperative for us to do, what our, fourth grade math teacher told us to do: show your work. How did you come to this conclusion? How do you know this? Why is this considered the standard of care? Why is this considered the kind of best legal practice? If you have a journalist, and sometimes our work necessitates anonymous sources, but we should tell the public everything we did to get that story and how that story came about. I called this person, I went to this archive, I got this document, I got a memo that was leaked from this office. I can put all this together, and you can see that everything I have said in this article conforms to the facts that I have in front of me.
Last question for you. As a father, as a journalist, as a scholar, as a, runner-up to the Pulitzer. Couldn't get the whole thing, but that's neither here nor there. Tell me about what gives you hope about the future of DEI in society at large, legal profession, and what you do in journalism every day.
I think, how weather and climate are different things. You can have good weather and bad climate, as people, have, sometimes mix up when we talk about climate change. The fact that it happened to be cold on this particular day in January doesn't mean that month wasn't the warmest January on record. And so we sometimes have to expand out to look at what the big picture is. And if we're looking at weather, it's inclement. It's difficult. But if we're looking at climate, I think in the big picture, we have fundamentally succeeded in moving in a more democratic direction more often than not. It's not undefeated. You're not 10-0. But as I was 8-2 will get you into the playoffs. So that's the idea that we look at, in the big scale of things. The sensibility that produced DEI and the efforts at democratizing the society and in creating a more inclusive society have won more than they've lost over the scale. That doesn't mean we're guaranteed to win. It just means that we have the possibility to win if we still have enough fight in us.
I love that. Dean Cobb, I know you are busy. Happy holiday season.
You too.
And thank you for joining me as we have fun at this CLE. Have a great day, and we'll catch up soon.
Thank you. Be good.
Thank you. Our next guest is none other than my good friend. I will tell you that he is one of the reasons that he and Donna Brazile actually are the reasons that I am having this amazing opportunity at CNN. He is a powerful voice. He's thoughtful. You all know him. His name is Van Jones. And one of the things that I admire about Van, there are two things. One, he's one of the unique figures that transcends race, gender, politics. He's able to talk to people for their core and their being. And the other thing is Van always has me thinking about the future in ways I don't think about it. Whether or not it's STEM, whether or not it's AI, whatever it is, Van is always, and back when he was in the Obama White House, that future was environmental justice, et cetera. He's been on the forefront of all the things that we care about, but none other than Van Jones. How you doing today? Thank you for coming and spending some time at this CLE, brother.
No, look, I appreciate it. It's an honor to get a chance to be with you on the air, in person, and now on the CLE. So we extending the brotherhood.
We are being versatile. That's what we're doing. Tell me some of the lessons you've learned from your social justice work, because I know the legal field is something that you utilize with great versatility, not just someone who in a courtroom per se, but from your social justice work, what are some of the lessons that can be applied to create more equitable opportunities for underrepresented groups in the legal field? And you can use some examples of some of the things I didn't even know, for example, your work that you did even before it was, I don't want to say a fad, but a hot item on transgender rights.
Sure. Yeah, sure. Yeah, yeah. Well, look, I mean, I think fundamentally, uh, there are two different paradigms on, call it diversity, call it inclusion, call it equity, call it whatever you want to. And one works a lot better than the other. Um, there's a win-lose paradigm that sometimes I think progressives like myself fall into, which is maybe best summed up as check your privilege, right? You have too much privilege. You're white, you're male, you're heterosexual, whatever it is. You have too much privilege. You are too ignorant about the privilege that you have. You're therefore deficient. And I need to correct your deficiency so that you can give up some stuff so I can have more stuff. That is less persuasive an argument than I think some, some of our progressive friends think.
I've been guilty of that. I have been guilty of that. So we're telling them to check their privilege. We have to check ourselves. I agree.
Yeah, exactly. So you suck. Vote for me. You suck. Help me. It just turns out to be not as persuasive as I think some people may have thought. We might want to check, some focus groups on that one. But it's ubiquitous. It's unconscious, and unfortunately, there's some truth in it. I mean, it's not like it's not true. It's just, as the Muslims say, truth spoken out of season bears no fruit. Like some stuff, is just, it turns out it's just not helpful to say, and also it overlooks maybe a deeper truth, which is that most people uh, have a hard time. Uh, most people don't feel that good about themselves. Black, white, male, female. Most people see themselves as a kid from somewhere doing the best that they can. And when you leave that out of their story, they it hurts. Um, Most men I know are in a lot of pain. Uh, Whether they're toxic or not, they're hurting. They're hurting and uncertain. Most men I know are hurting and uncertain. Not sure how we're going to be able to feed our families. Not sure how we're going to be if we're going to be able to relate to our kids. Our kids grow up in this weird world with all these different platforms and gender identities and all kind of stuff we didn't have. We didn't have that stuff in the '80s. I don't know what y'all be talking about half the time. And so there's real pain there. But I'm just a toxic man, so shut up. It doesn't work. There's another model that I think works better, which is to remember how much better off all men will be, how much better off all white people will be, how much better off everybody will be when we're in a win-win world where everybody's balling out of control. That, my argument to the white guys is, you don't have enough. You don't have enough. You don't have enough partners. You don't have enough contracts. You don't have enough friends. I want you to have more. I want you to be able to go anywhere in the world, do deals with anybody you want to, have them feel great, have you feel great, your profit goes up, their profit goes up. I want you to have a fantastic life. In order to do that, there's some mindset and skill set additions we need to do so you can have a great life. Oh, and by the way, maybe then my kid, in a world where you're doing great and I'm doing great, maybe my kid won't get shot by the cops, but that's my kid, okay? I want your kid to look at you and think that you're great. How do I engineer that? Well, guess what? There's something called diversity. There's something called inclusion. There's a skill set that if you had, your life would be amazing. If you had, your kids would think you're the coolest dad ever. So now I'm not trying to convince somebody that they suck and then you give me something, okay? I'm trying to convince somebody that they're awesome and could be a lot more awesome. And I have found that has been the key. As you know, I've done a lot of stuff people thought was impossible. I've gotten Republican governors to sign criminal justice bills. I got Donald Trump to sign a bill. Me and many others got Donald Trump to sign a bill. The First Step Act let 40,000 people out of federal prison. He signed the bill and handed me the pen in the Oval Office as a liberal Democrat. So that's available if our heart is right. The reason that you love Ella Jo Baker, the reason that you love Fannie Lou Hamer, the reason that you love Cleveland Sellers, the reason that you love Martin Luther King is because somehow in the hell of hell, of American segregation, racist terror, apartheid. We don't even have enough word. Jim Crow does not do the job for the rapes, for the lynchings, for the day-to-day indignities that our folks went through. Somehow they came through all that as diamonds. All that pressure, they came out as diamonds. Moral diamonds that will shine in the firmament of human history forever, because they just refuse to let themselves be dehumanized, and they refuse to dehumanize anybody else. It's a miracle in human history what they were able to do, your dad and others. And so when you get away from that, when you forget that we're actually trying to free the jailed and the jailer, that, right? I don't mind talking about oppressed and oppressor. I think that's a reality to that. But we're trying to free them both. We're trying to get both people to a much better place in their lives and in their hearts and in their soul and their relationship with their creator, that we're ministering to all of us, not chastising some to elevate others. When you do that, it's hard to stop you. I mean, we luckily we don't have to invent it. Your dad had to invent it. You know what I mean? We don't have to invent it. We can just remember it. It's a lot easier to remember the stuff that your dad did than for us to have to make
Yeah.
it up ourselves. But for some reason, we just forget that they were ever here. And so we just be like, you suck. You're a racist and a sexist and a fool and an idiot. Now, please help me. It's like, it's not going to work.
One of the underpinnings that you're talking about is this concept that my dad and King and all others, and it kind of underpins DEI, actually, which is a very generic concept, which is loving your neighbors even when they don't love you. That's hard as hell, but it is it's necessary. It's a necessary underpinning to those concepts. One of the reasons that I thought about you when we were preparing for this CLE is because you are on the precipice and you're learning a lot, teaching me a lot. You've actually sent me some books, which I've read, or suggestions for books, which I've went and read on AI and where we are, the forefront. And it has the potential to improve access to justice, which is huge where we are. But as we're talking about this, how can we ensure, and I believe this conversation we're having today, it may not resonate or land this year. It may not resonate or land the next year, but this is going to be something that's very important in the very near future. How can we ensure this technology benefits underserved communities without creating new inequities?
It will create new inequities. That's baked in. And it will.
Thank you for pushing back and throwing out the question.
No. But no. Look, Dr. King and Cleveland Sellers and Ella Jo Baker, Family Hamper, all the great heroes, they were fighting for two things. They were fighting for equal protection against bad stuff. They were also fighting for equal opportunity, equal access to the good stuff. The bad stuff is coming from AI. We know that there's racial bias in the algorithms, and then when you try to fix it, you create all kind of weird stuff. They tried to fix one of the algorithms, so then the AI overlearned it. So then he said, "Show me a picture of the founding fathers." It was like all black women. It's like, no, that's not. We went too far. So we know that this is going to be hard on the racial bias. We know it's going to be hard on the job replacement. I can't do much on equal protection from bad stuff, though others are working on that. Was make sure we get equal access to the good stuff. There is good stuff coming from AI. I think especially for those of us who are on the front lines of justice, it's expensive to do the stuff that we do. And that's why, most of us are not billionaires doing this work. Our clients don't have much money. Governments don't want to give us money. Got to beg these foundations and philanthropists to give us stuff. It's very, very hard. If you can increase your margins, in other words, reduce your expenses, that's a smart thing to try to do. And the reality is existing AI platforms already can help you do that. There's a book called Automate Your Busy Work, which I found very challenging, but also very good because it forces me to think more like a machine. What do I do every day, all the time? I shouldn't do that. That I could have an AI agent do for me. And there are companies and platforms that do it for relatively cheap. There are Black people now who are, I was just at John Hope Bryant's conference down in Atlanta. There was a sister there named Kat something who was showing like Black businesses, Black law firms, Black dentist offices could save money by automating a bunch of stuff that we do all the time. So that's something that's important, but much more important than that. we cannot allow the future to be authored by a very small group of people
Mm-hmm.
who are mostly, let's call it what it is, mostly straight white guys and some Asians who life experience is very narrow. These people are very young often. They're often under 30, under 40, almost all of them. Um, they, some of them have really only been in academic environments, um, suburban environments, elite environments. Those people should not dictate the future for 8 billion people. That's just not. The last time a small group of people dictated the future, we had 400 years of hell. Okay, 400 years of colonization, 400 years of slavery, 400 years of imperial wars. So we don't want a small group of people to dictate the future. What we do want and need is more people to engage. Now, how do you do that? I've launched a campaign called Make Wakanda Real. Okay, make Wakanda real. All right, so that's because right now it's all Terminator and RoboCop in the imagination. I believe, what you think about often comes true. If you look at your own life, stuff you're scared of actually happens, stuff you hope for actually happens. So right now, the whole global imagination is either RoboCop or Terminator or Matrix. But there's an African or an Afrofuturist vision of technology being used by Black people for good, and it's called Wakanda, and it's in the Marvel superhero universe. And that should be the goal. We should make Wakanda real. We should get all this technology and use it in our community for good. We should try to create unfair advantages for Black businesses, unfair advantages for Black community groups, unfair advantages for Black lawyers by leveraging the hell out of AI. And if we can do that, I think that we can actually have a positive outcome, at least for the people that we care about. Will there be other stuff that happens that's terrible? Yes, it's always going to be the case. Will we have to respond to that? Yes. But if all we're doing is playing defense on the bad, and we're never taking advantage of the good, even when we win, we're still losing. So other people are going to be very tough on the AI companies and that kind of stuff, on the bad stuff, and they need support. But somebody's got to gain some yards. I mean, what if we went to Atlanta or any city that you like and said, we're going to take the top 20 African American businesses, the top 10 churches, and this summer we're going to make sure that they are outfitted with the best AI everything, because we're going to aggressively confer unfair advantages to our community. That would be interesting to do. Now, people tell me all the time, but Van, Negroes ain't going to do that. 99% of Black people don't know nothing about AI. 99% of Black people don't know anything about quantum computing. 99% of Black people don't know anything about Bitcoin, crypto, biotech. 99% of Black people don't know anything about what you're talking about. I said, you are correct. And 99% of white folk don't either. Because it's new. Because it's brand new. This is the only equality you are ever going to experience if you're Black. We all equally ignorant about all this new stuff. This is reparations. This is reparation. All we ever wanted was a fair, easy shot. So look, 99% of us don't know, 99% of them don't know. So it's even Steven. So there are YouTube channels, Reddit. I'll throw a bunch of books at folks. And guess what? As soon as you start using any of this stuff, your productivity goes so much farther than your colleagues, you're going to start using it more. If we grab it first, and thank you folks for putting all this stuff, by the way, I've fought for a long time against the digital divide. I was, fighting against that stuff 20 years ago. That doesn't exist in this context. The hardware is already in your hand. The software you can download for free right now. ChatGPT, Gamma, all is free. It's not a hardware problem. It's not a software problem. It's a wetware problem. We don't believe that we can dominate this century with justice, with beauty, with wisdom, with our needs being met, with this technology being used for good. And so there's an imagination gap, much more than there's a technological gap. All this stuff is brand new and free, and it's it could be on your phone right now. So if we can close the imagination gap, Will.i.am and I are working on this, Make Wakanda Real thing. If we can close the imagination gap, why don't we have the Black equivalent yet of Singularity University? Singularity University teaches all this exponential stuff it's not that expensive, but it's just, for most Black people, very culturally alien. Like the way they talk is weird. And it's just we're not trying to eat that, mashed potatoes or whatever that potato salad got raisins in it. It's not our shit. But we could build the same way that our great grandparents and grandparents built Black institutions to teach Black people stuff they needed to know in that century. We could do that in this century. So these are things I think about all the time, and I'm just glad to have a chance to talk with you about it because, as you know, I'm completely.
No, I can listen to you talk about it all today because you're challenging me to like break my norms, and people watching, you're like, okay, Van's right, let's break our norms. And a lot of lawyers, when you start talking about AI, when you start talking about efficiency, you start talking about cost savings, they're like, wait a minute, this is something I need to go ahead and jump on board with right now. But I can also hear this conversation in the barbershop. So my question to you is, what role can AI play in democratizing legal knowledge? But also the barbershop conversation is, how do we balance this accessibility with concerns about privacy and accuracy? Because I can hear my daddy saying right now, man, I don't want them AIs in my business, thinking it's a whole new race of people. So how do we balance that?
Look, I mean, the reality is, you have to pick what problem you want to have. That's just it's just like, until we start designing all this technology and do it perfectly and coordinate the values that we care about, then there's going to be some trade-offs. I wouldn't be look. The big AI companies are trying to vacuum up mega sets of data. I mean, your little company is not. They're trying to vacuum up everything on YouTube. You know what I mean? That's like, to them, like that's a healthy snack for them. Everything on YouTube, everything on Reddit, everything like the entire everything on Wikipedia. So these are big Pac-Man companies going and gobbling up massive amounts of data. Your little legal shop or whatever is just honestly like there's a certain narcissism of like this comes from just like being in our own body and looking out and thinking that we're the center of the world. People used to think the earth was the center of everything. Like, you're no more the center of the AI agenda than Earth, this little green soap bubble in space, is the center of the galaxy. It's just like it's a rounding error on a rounding error on a rounding error. But your competitor who decides, well, shoot, I can use this, and instead of my, at least my draft pleading can take me literally 5 seconds to write, and then I can improve it, as opposed to the draft takes my associate 2 weeks or all weekend. So it's just, what problem do you want to have? I like to have the problem of going too fast. As you know, a lot of times I go too fast, Black people get mad at me, what this Negro doing, blah, blah, blah. Like, but I would rather have the problem of going too fast than the problem of going too slow. Because I'm, unlike you, I'm not well known and well loved by everybody, so that I can like, you have to manage a bunch of social shit. I don't. Everybody loves you. They want you to come to their parties. They want your opinion on everything. You got to go save everybody. Nobody calls me for nothing. So
Except me, I call you all. I call you all.
Exactly. Yeah, you call me. So given that the only thing I have is just the advantage of I can go fast. I care a lot about justice. I care a lot about people who don't have anything, especially Black folks. But as you know, last time I went to jail, I didn't go to jail for Black people. I didn't go to jail with Black Lives Matter. Last time I went to jail fighting for coal miners in Appalachia who were getting their pensions stolen, and we won that fight. To your point about transgender folks, in 1997. I helped to create the first organization ever to fight for transgender rights when it came to police and prisons. Because in 97, when the LGB community, and they had just fought to get the B in there, didn't want to have nothing to do with the T. But listen, I'm talking about the 90s, man. In the 90s, nobody could get married. Civil unions were considered controversial. And transgender people were not wanted by the lesbians and the gays. They were like, y'all are too weird. And so they were transgender sex workers in the Tenderloin. People were coming from around the world to have sex with a tranny. That was a thing. But what would happen is frat boys would go to the Tenderloin in San Francisco, beat them up. Cops would beat them up, arrest them for sex crimes, but also sometimes molest them. Then put them in unsafe jail conditions at the San Francisco County Jail. If you put somebody that looks like a man in a dress in a jail, you don't have to ask the next question what's going to happen. And so these were horrors being visited upon this very vulnerable population. So we created an organization called Transaction. Always been good with names. Transaction to put an end to all those abuses. I had a black civil rights civil rights police brutality group called Bay Area Police Watch. There's another gay and lesbian group called CUAV, Community United Against Violence. Neither group was doing a good job serving this population, so we created a joint task force called Transaction, changed all the laws and the policies and regulations. The stuff we fought for in 97, 98 for the San Francisco County Jail is now the global standard for transgender stuff. So I'm somebody, I've always tried to fight for people who didn't have much, whether they look like me or not, love like me or not, vote like me or not. That's not important to me. I'm a Christian. Nobody else has to be, but I'm just telling you. For me, when they told me as a child, Jesus is going to judge you by how you treat the least of these, not the billionaires, not the celebrities, the least of these, the people who don't have much. That's what I've focused my whole career on. You there? Did I lose you?
I think my guy Van Jones just froze. There he is.
Oh.
He's back. He's back. Listen, I got 3 minutes with you. First of all, let me also just do this because we don't do this enough. Thank you for spending some time today. I know that we don't often say thank you to each other. We take that for granted, but I do not. But even more importantly, thank you to your team. The people around you are amazing. And I know dealing with you ain't gonna be the easiest thing in the world.
Ever.
Ever, but they are dope. So I want to wrap up with one question to get you out of here in your right time frame. And I'm going to tie it in. Some of the things we care about are criminal justice. How do we use AI in criminal justice going forward? And then as someone deeply engaged in systemic reform, what advice do you give legal professionals so they can be true agents of change in promoting DEI?
Look, on the criminal justice side, AI will be a blessing and a curse. Evidence is going to be very hard to, it used to be photographic evidence was all you needed. Now you're going to have a second, like you can fake a lot of stuff now. So people may get away with stuff they shouldn't get away with, or they may get in trouble for stuff they shouldn't get in trouble for. So I think AI is going to be a mixed blessing. The main thing that AI just helps with is just efficiency. It's a jetpack. Most people look at AI as a hand grenade. It's going to blow up their life or blow up their field or blow up their community or blow up the world. It will be that for some people, but for you, it can be a jetpack. Think of AI as a jetpack more than a hand grenade. How can it help you? You do not work for the federal government. You cannot regulate it. You don't own any of these companies. You're not an investor. So you can burn a lot of calories worrying about stuff you can't do anything about. Most stuff you can do something about. If there's some law you don't like or something like that, or a candidate you don't like, this thing is on a train going fast. And so most of the stuff that people worry about, they can't do anything about, but you can at least benefit. So I think that's true. And then as far as, on the DEI stuff, I spoke to it earlier and I'm going to speak to it again. Most people are reacting to something that they can't put words to. They know that we are wasting a lot of genius in America. They know the kids in Appalachia and trailer parks and housing projects and Native American reservations, they know they don't have a fair shot. People know that. They do know that. They wouldn't want their kid to live there. You know what I mean? And so people know in their heart that that's true. People worry that the people who are pushing for more inclusion don't like them. We get tricked in the kind of identity politics game that we have to play because identity does matter, no matter what anybody tells you. But we sometimes think the main thing is, are you like me, right? Are you black like me? Are you lesbian like me? Do you vote like me? Are you like me? Because that's going to determine a lot about our relationship. For most people, that's kind of important. But what's more important is not, are you like me? It's, do you like me? Do you like me? Can you see me as a person? Am I just a straight white guy that you have to like depose? Or am I like a veteran, a union guy, a dad, a granddad? Is there something about me that you like and can identify with and want to protect too? Because if I know that you like me, if I know that you care about me, I know I'm willing to do a lot for people that like me. I'm willing to do nothing for people who don't like me. Period. So, like, I don't care if we agree on 99 things. If you out here talking crap about me and hate me, I'm not doing anything to help you. And so there's some stuff we're missing, some kindergarten stuff. We so far in the PhD of it that we forget there's a lot of just PhD of just how the emotional intelligence of it. Just making sure people understand that we're on their side. We really do want all boats to rise. We're not trying to sink your boat so that somebody else can rise. We really want all boats to rise. And so it's the hard part. It's not the smart part. Everybody I know in DEI is very smart. They've read way more books than the average person. They know a lot more. They got more statistics. They understand the dangers of unconscious bias in ways that are breathtaking and very, very smart. It's not the smart part, it's the hard part. You can get so triggered by all this injustice happening to all these folks, and the wrong part of your brain cuts off on, and so you wind up in a fight flight. And so then when you're in a fight flight trying to deal with somebody else, you can trigger them into a fight flight without knowing it. So there's a lot of emotional intelligence. There's a lot of literally neuroplasticity. People need to study brain science. There's a lot of stuff that it's not the stuff that you can see that's causing us the problems. It's the stuff that we don't see. We have some blind spots too. Anyway, look, I saw you had Jelani Cobb on here. I'm on here. I just want to say, most people in your situation, they just go and grab their old 3-ring binder from the last time they did a CLE and read a bunch of stuff. You look at the top of their head, and people are just going to sleep. Like, for you to be working this hard on a CLE, bringing some of the best people in American life to, like, thank you. I mean, you set a standard for excellence in everything that you do. You always have. But just to be included in the roster, I appreciate it, brother.
No, I appreciate you. I love you. My best to your family, your children on this holiday season. Wish nothing but health and happiness as we go into New Year, brother. We'll talk soon. We'll catch up.
All right, peace.
Peace. So that was amazing. Having Van Jones is always amazing. We've had Dean Jelani Cobb. And for the final 30 minutes, make sure that your laptop is still open. I know you're running to the bathroom with your laptop open. I know you're headed to the bar in your kitchen. That's fine. But trust and believe that is fine with me. I hope you found this as engaging and as interesting as I have. We're actually bringing back my good friend Elie, because we're going to talk about the future of DEI. And if you have any questions, I know we'll be able to take some questions from the audience. Go ahead, please, and be thinking about those, thinking about that. We'll bring Elie back up right now because I want to talk to Elie about the future of DEI in the legal profession. Is there a future? Is probably where we'll start of DEI. And to be honest with you, given the Supreme Court's decision in Students for Fair Admissions versus Harvard, practically, what do you see as the most significant implications for DEI initiatives in education in the workplace?
Yeah, so that decision was real bad, right? And one of the best ways to understand how bad it was because it reimagined the 14th Amendment to do something it didn't do, right? The heart of the Students for Fair Admissions argument was that affirmative action was unconstitutional under the Equal Protection Clause of the 14th Amendment, right? Now, the Equal Protection Clause of the 14th Amendment was written specifically so racial restorative justice programs could be enacted. And you don't have to take my word for it. The people who authored the 14th Amendment of the Constitution also authored the 1868 Civil Rights Act, right? The first Civil Rights Act in American history. And they said they couldn't pass that law until the 14th Amendment was ratified. That they didn't have the constitutional backing to pass that law until the 14th Amendment was ratified. So to now reimagine the 14th Amendment as something that does not allow for racial remediative and restorative programs is simply false. But that's exactly what Clarence Thomas did. And here's the thing, Bakari, and you know these people as well as I do. one of the real, I think, intellectual bankruptcies of originalism, which is what the conservative justices on the Supreme Court claim to practice, is that whenever originalism doesn't give them the answer that they want, doesn't give them the outcome that they want, they either abandon originalism or make something up. And in SFFA, that's what the court did. Clarence Thomas, in his concurrence in that thing, literally said that the Freedmen's Bureau, which was arguably the very first affirmative action policy in America, it was designed to help former slaves find jobs. That the Freedmen's Bureau was race neutral, because the Freedmen's Bureau didn't apply to people based on their race. It applied to people based on their condition, their former condition of servitude, which is false, which is not true. I mean, beyond even getting to the fact that, like, it's like a square versus a rectangle thing, right? All squares are rectangles, but not all rectangles are square, right? All the slaves were black, not all black people were slaves, right? So trying to disambiguate the Freedmen's Bureau on a racial grounds versus a condition of slavery grounds is intellectually a thin slice of the salami, shall we put it. But it's also just straight up wrong, because the Freedmen's Bureau also applied to free black people living in the North who hadn't been enslaved. You could also go to the Freedmen's Bureau and try to get a job if you were a black guy in New York, right? So, like, but this is what originalists do. They either abandon it or make something up. But because of what they've done, because what they have said is that the 14th Amendment means that equal protection of laws have to be given regardless of race, and that means helping people from historically disadvantaged groups overcome legacies of white racism. That's suddenly frowned upon in this establishment. That has a knock-on effect, not just at colleges and universities, not just at elite institutions like Harvard, which, frankly, they'll be fine. They'll figure it out. It has a knock-on effect throughout the rest of society. And so now fast forward to Project 2025, and what you see, Bakari, is a complete reimagining of the Civil Rights Division in the Department of Justice, right? Currently, headed by Kristen Clark. I would argue she is far and away the most competent DOJ official there in the Biden administration. But that's a different program.
That's a different CLE. That's a different CLE.
Right? But what they want to do with the Civil Rights Division is to change it into a thing that sues on behalf of white people who feel like they've been denied from various opportunities because of DEI. And that is just, remember, what we're talking about is white folks who think that not just a black person who has a job or a black person who gets into school shouldn't have gotten that job or shouldn't have gotten that placement over a white person. They think that every black person who got a job or got into school shouldn't have gotten into school because there was a better performing white man available. We were talking earlier about some of the big affirmative action cases, 2003's Greta v. Bollinger, 1974's Regions of California v. Bakke. One of the things that you have to remember is that in both of those instances, the plaintiffs were white people saying that they should have gotten into medical school and law school, respectively. They couldn't point to the black person whose spot they should take. They couldn't say, oh, no, I want to go into University of Michigan and I should have gotten in over Tyrone, right? Tyrone took my... They couldn't say that. They said that any black person who was in that school got a spot that should have been given to the white person. Anyone under these programs should have been kicked out in favor of the next best available white person. That's the core of the argument, and that is the core of the argument that we're seeing today. So you can imagine a black person being hired anywhere as a firefighter, right? Well, black people shouldn't be hired as firefighters. I'm a white person. I didn't get a job as a firefighter. So now I can sue the fire department because they hired a black person, is the thrust of the argument. And that's what Project 2025 wants to turn the Civil Rights Division of the DOJ into.
One question that I have is, I believe that the three most consequential events since I've been born, I'm not going to go back prior to 1984. I was born September 18th, 1984. But the three most consequential events are actually events that involve jurisprudence. And I'm going to kind of set the table for this question. The first was replacing Thurgood Marshall in the Supreme Court with Clarence Thomas. The second was conservatives running Harriet Miers out and replacing Harriet Miers with Samuel Alito, who made his God's journey to overturn Roe v. Wade and was successful. And the third was the notorious RBG, or Ruth Bader Ginsburg, staying so that she could swear in the first female president of the United States, which, as you can tell by this date and time, has never occurred. So thinking about those three historical moments, which I believe are the most consequential of my lifetime, and then adding to the fact that you probably will have the retirement of two of those justices, in Samuel Alito and Clarence Thomas, during the next 4 years. What does the Supreme Court look like in the future with this level of conservatism as it applies and affects DEI?
I mean, look, if you look at the actuary tables, like, the things that life insurance people use, which I've looked at just for
Please
no
do
reason.
not come on here and say that all these old people are about to die.
If you look at the actuary tables, the projected, and assuming the normal, push and pull of Democrats win, Republicans win sometimes, blah, blah, blah. The best case scenario before this election was that Democrats might have an opportunity to take back the control of the Supreme Court by the year 2045. That was before this election. That was before Donald Trump got reinstalled with a Senate, with a Republican Senate. That was before Samuel Alito most likely retires before 2026. That's before Clarence Thomas is most likely pushed out before 2028 and are replaced by like 25-year-olds that pledge loyalty to Trump straight out of law school, right? That's before. So when you now add in the fact that two of the oldest justices, Republican justices, are likely to be replaced by two young Republican justices, I'm pretty sure that actuary table is going to push the event horizon out to something like 2060 before Democrats can reasonably expect to even have an opportunity to take control of the Supreme Court. And that's assuming that we still live in a country where Democrats are allowed to compete and win elections, which I don't know about, right? So the court is gone for the natural lives of most of the people listening to this, right? And certainly of me, right? Like, the court is gone for my lifetime. What does that mean in kind of practical terms for DEI? This is a court that's incredibly hostile to the ideas of diversity, just incredibly hostile to inclusion. And again, we see that not only in their rulings, we see that in their personal hiring practices. As many people know, but not all, the golden ticket, the most important job you can get to set your career coming out of law school is to be a Supreme Court clerk. The current Supreme Court clerks are the ones who go on to be the law professors and Supreme Court justices of the futures, to say nothing of CEOs of mega titan law firms, right? It is the golden ticket finishing school on your legal resume. And the clerks are almost always all white. Sometimes some Asians, sometimes some women, but almost always all white. Clarence Thomas actually does a fairly good job of trying to get one or two Black Republican clerks in there. But the rest of them generally do a terrible job. Ruth Bader Ginsburg, who you mentioned earlier, 29 years on the court, had one Black clerk. One in 29 years. Hero of whatever movement. One. It was a man, not even a Black woman. The Supreme Court, even in its own hiring practices, are adverse to diversity and adverse to inclusion, to say nothing of their actual legal decisions. So when these 9 people, and it's going to be 9 for the foreseeable future, are the ones in control of telling us which laws are constitutional under the 14th Amendment. And they've already tried to neuter the 14th Amendment and metastasize it into something that it was never meant to be. Over the objection, by the way, the strong objection of Ketanji Brown Jackson, who literally did originalism in her dissent from the SFA ruling, right? Pointing out how the originalists were hypocrites on their own terms, right? But when you have these 9 people in control, it's hard for me to think of a program that passes muster. It's hard for me, and I mean that, I don't mean to be hyperbolic when I say that. It is hard for me to think of a diversity, inclusion, and equity program that passes muster in front of this Supreme Court. Certainly one, not one where for an organization that is taking government taxpayer dollars. It's just hard for me to think of one that survives. And what that means is that, you know how they say in the book on tyranny, don't obey in advance? What that means is that we have a lot of institutions and universities obeying in advance and trying to preemptively change and mutilate their inclusion programs so as to avoid a lawsuit. Stephen Miller, incoming deputy chief of staff for Donald Trump, he's already, when he was out of government, was running around threatening every university under the stars about their diversity programs, arguing that the only way to know about whether or not you were following the court's prohibition of affirmative action was that Stephen Miller had to understand your entire admissions process, right? The only way to prove that you're not using affirmative action is if the number of Black applicants goes down. Doesn't matter how you do it, it has to go down. Because if it doesn't go down, then Stephen Miller says, well, you're still using affirmative action. Ed Blum, who was the legal gadfly in charge that collected the group of allegedly Asian American students who sued Harvard. I mean, it was Asian American students, but it was organized under the banner of Ed Blum, right? Ed Blum is taking his fight to corporations, right? He is literally using the same.
So that's my next question. So what's the practical impact of this ruling on non-government actors?
Yeah, so that's and it's more lawsuits, right? Having defeated essentially colleges and universities in the Supreme Court, he is now taking the fight to other government contractors, other places that get their funds, that get taxpayer money, right? Hospitals, police departments, things of that nature, where again, the argument is going to be, think about it from the perspective of a police department. We have had so many conversations in our communities and others about the desperate need to have people from the community police the community, right? One of the best ways, not saying that Black cops can't also be brutal and racist and awful, but one of the best ways to lessen the amount of police brutality Black people have to face is to have police officers who serve their communities from their communities. And Stephen Miller and Ed Blum are going to say that's not okay. That is also unconstitutional under this new metastasized, hobbled version of the 14th Amendment. But Bakari, that's honestly not even my biggest concern. The lawsuits and the continued legal attacks on DEI, that's not even my biggest concern. You know what my biggest concern is? Doge. The Elon Musk, Vivek Ramaswamy organization. There is a bill currently in Congress that's not going to pass this Congress, but is going to come back from the 119th Congress that Republicans have control and Trump is at the top of, called the Dismantle DEI Act, right? And this bill would fire every federal government employee who is currently in their position because of DEI. How do you define who's in a position because of DEI? Oh, wait, they can't. So it's actually just fire all the Black folks in government. Fire them all. And then the kicker is that according to this bill, if this bill passes, they will say that people who have been fired because they were involved in DEI are not allowed to reapply for their jobs under, whatever non-DEI rubric they're going to come up with, or to apply for any other government job. It's creating a class of Black folks that is literally unemployable in the federal government because of this bill. Now, this bill reminds me of an act from 1911 called the Mine and Works Act. And if you're an American lawyer and you don't know what that act is, that's okay, because it's not an American law. It's a South African law. It was the law, it was the pre-apartheid white South African law that established what we now call the color ban in South Africa. And what the 1911 Migrant Works Act said didn't mention color, didn't specifically mention race or color. What it said was to get a job in the mines in South Africa, which, South Africa, a ton of mineral wealth. This is a big part of the South African economy, especially in the 20th century. To get a job in the mines, you had to be certified by a government agency. And quite simply, all the government agency would do would be to refuse to certify Black people for leadership positions within the mines. Oh, you could be a miner, right? But could you be a foreman? Could you operate the machinery? Could you be taught how to operate the machinery? No. You had to get a special certification from the government, and the government wouldn't certify Black people for those jobs. Does that not sound like exactly what Doge is planning? What does that not sound like exactly what Elon Musk, whose father was a white South African who made his money running emerald mines in South Africa? Does that not sound like what Elon Musk is planning for the rest of us? To fire everybody and then have a system where only Doge gets to say who is actually qualified to hold a government position? Because it sure as hell sounds like that to me. And I think, Bakari, that is what's coming for the future of DEI. Not simply getting rid of all the programs. At some level, getting rid of all the programs is the easy stuff. That's the low-hanging fruit that these people have been planning to do for a generation. No, the real shaft of the spear here is to make Black people unemployable in certain high-profile government positions, unless white South African Elon Musk says it's okay. So,
Let me ask you.
Herschel Walker
Let me ask
will
you
be
this
able to get a
question.
job, but not you.
Let me ask you this question. As I kind of wrap up with you, you have legal professionals watching. What strategies should they adopt in other institutions, even in this climate, to continue to advance DEI while navigating the constraints as you set forth?
So I'm a big fan in terms of best practices, in terms of having hiring committees as opposed to having one person in one position making all the hiring decisions for your organization. I think that is one of the low-hanging fruit, best things that you can do, right? Because if it's just one person, that person is naturally going to favor people who look like them. And if not look like them physically, look like them, experientially, right? Come from the same kind of schools or towns or have the same backgrounds or experiences. That's just natural. I tend to do it too. And so as a hirer, as an employer, I am always trying to make sure that I am never the only voice in the room. To quote Kermit the Frog from Muppets Take Manhattan, we need more dogs and cats and chickens and things up in this room, right? We need more people involved to have their hands on the hiring process. That alone kind of decreases the amount of racism and sexism and bigotry that can happen in the hiring process if you just got more people in the room helping to make the decision, right? So that's one, just straight up low-hanging fruit thing that I always kind of emphasize, right? The other that kind of falls on that, but if you don't have a diverse hiring committee, then you're not going to hire diverse people. You're just not, right? That's just not something you're going to be able to do quite effectively. So however your organization or your institution goes about making these decisions, it's got to be coming from a wider pool than just the old boys network, because the old boys network are going to feed you the same kind of people over and over again. And some of those people may be Black, right? Because there are quite a few Black people who can, as I said, we can code switch like nobody's business. We can survive just fine in predominantly white environments. But then have you done diversity or have you done tokenism is the question that comes next, right? So resist tokenism. And pull from have your hiring committees pull from a diverse background, be from a diverse background, and then you will pull in a diverse series of applicants. And the third thing, we kind of already mentioned it again in the Bollinger case. Critical mass is a thing, right? Like it is, if you were, I see this all the time in law, where, as I've already mentioned, there is a very small pool of people of black lawyers, of black law students, right? Like relative to the rest of society, it's a small pool, and the more elite you go, the smaller that pool gets, right? And, once you start pulling from only the top 15, 20, 30 law schools, which a lot of the top 100, 200 firms do, it's a real, I'm not saying we all know each other, but like we do the what's up thing in the bathroom, right? Like you reckon game recognized game. And so like when you are one of that very small group, you are looking for firms and institutions and opportunities that hire in-group members, right? It is, I can walk into a firm. If I walk around and I don't see any black people besides the receptionist in 20 minutes, I'm like, it's probably ain't a place that I want to work, right? If I see a couple of chocolate chips sprinkled in there, and then I'm like, all right, maybe I can have a conversation with some of these people. Maybe they can tell me the real down low about what this firm is like, what the culture is like, what the institution is like, right? Critical mass theory is real. And so if you're committed to hiring a diverse environment, it cannot be tokenism. You have to have multiple people from varied experiences so that everybody feels comfortable, and quite frankly, so everybody feels like they have somebody to talk to.
Talk about some resources that people need, cases to read, resources. You already named the historical cases, books, information, for people to go out and just be better at this.
Oh man. Let's see. Look, obviously, look, I read all the cases, so like read cases. They're important. I'm trying to think. Look, Cheryl Neifel, Janae Nelson at the NAACP Legal Defense Fund, they do this work every day, right? And I have the NAACP Legal Defense Fund's press page, like literally bookmarked on my screen for just like when I'm just looking for stories, like when I'm just looking to figure out what's happening. I check in with them regularly to see what they're on about, what they're talking about. That's what I'm looking for. The law is complicated, but not inaccessible, right? Like you can figure out, even if it's not your field of law, even if it's not the thing, that you do most of the time, right? You're a tax lawyer, you can figure out this stuff, right? Like it's not beyond you. And so, yeah, I tend to follow other legal professionals who are out here doing the work while I'm, just shouting on television.
The Harvard Business Review also is an amazing, Harvard, here we go again, but they have done a lot of work on implementation of DEI and making sure that people had the resources necessary to do it. One of my questions for you is, being somewhat forward-thinking and forward-looking, are there any strategies that we can employ legally? Because this assault on DEI hasn't come overnight, right? This isn't something that's like Roe v. Wade. The overturning of Roe v. Wade through Dobbs didn't happen overnight. Are there anything that we can do as legal professionals in our field, particularly in courtrooms, to maybe chip away or regain some of the progress that was lost?
Yeah, so I generally am at a moment where I'm like, stay away from the Supreme Court at all cost, because these people are off the chain, and they're filling themselves, and they're dangerous right now. I would argue keeping anything away from federal court possible, but state court, that's different. That's a different kettle of fish entirely. And I think that just politically, there are more opportunities for liberals and liberally minded people to make inroads at state courts. And there are pockets of state courts around the country that could be a little bit more amenable to some of these practices, like New York, right? Like Delaware, where a whole lot of places are incorporated in those two places I just mentioned, right? Because, and maybe this is a good way to end it, remember what I said at the top, Executive Order 10925 is pretty much the only federal mandate ever for any kind of DEI, diversity, inclusion program. All the rest have been done because private actors, private institutions, universities and colleges, various law firms have independently decided that having a diverse environment is good for their business. I always get annoyed that the Chamber of Commerce isn't more out front on this issue, because in so many instances, it is a business decision to have a diverse working environment. It interrupts the groupthink. If you're in business, it interrupts the groupthink to have people from different backgrounds with different perspectives looking at different lenses, even if what they're looking is how to make number go up. It just interrupts the groupthink on that question. I also feel like certainly if you're a consumer-facing business, there's a reason why if you turn on BET, all the McDonald's ads have black folks, right? All of a sudden, they cut 2 ads, folks, right? They cut the white ad and the black ad. And they probably cut 14 because there's probably a Latino ad that I haven't seen. There's probably an Asian ad that I have, right? McDonald's understands that you want to be served by your community. And so for a lot of these businesses, it is a business decision. It is a positive business decision to do diversity and inclusion. And there are state courts that are hyper-focused on business concerns, New York, Delaware, California, that understand that and will protect. I mean, not Florida. Don't try to do any Disney kind of stuff. But, there are pockets around the country where I don't think the battle is completely lost. But keep the hell away from federal court, because it's not where anybody
Thank
wants to be
you
right now.
for being so uplifting today. Elie, thank you for taking some time to join us. Is there anything you want to leave? You're speaking to lawyers around the country. Anything you want to leave them with other than stay the hell away from federal court?
Watch out for apartheid, honestly. Because that's what's coming next. Watch out.
Thank you. Anyway, deuces. I'll see you in our chat soon, Elie. I want to give a special shout out. I want to give a special shout out to everybody who's joined us today, all of our guests. I want to give a shout out to Elie Mystal, a shout out to Dean Jelani Cobb, a shout out to Van Jones, and then again, Elie Mystal, for just taking some time out, answering my call. Their team's working with us to put this on today. Whether or not you're watching us live or you are picking this up later, this has been an amazing experience for me, being able to bring this to you with some of my good friends. I mentioned earlier in the CLE, simply about things like some consequential moments throughout our country's history, whether or not it was what's happened with the Supreme Court, or whether or not it's things like Briggs v. Elliott in 1949, or Elmore versus Rice that happened in 48, 49, or whether or not it was Fleming versus SCE&G. All of these cases and events have created this contour where people like me in particular and others value what we now know as diversity, equity, and inclusion. It shouldn't have this clash with quote unquote wokeism or free speech, but instead it helps improve your bottom line. Diversity, equity, and inclusion inherently brings value to not only your business practice and your legal profession, but your everyday life. And so I hope that you understood some of the history about where we are and some of the ways it's covered in our journalism and media. Also, some of the ways that it's going to be implemented in our new horizons, such as AI, et cetera. And then last but not least, kind of the future of diversity, equity, and inclusion, as dire as it may be. And so last but not least, I have to thank Sprout Ed. Sprout Ed is the reason that I'm here. They have this unique vision for making sure that they put on these high quality continuing education classes for all of us. And this is a unique experience. It's a little different than our normal CLEs where people speak at us, talk at us, we fall asleep, we doze off, or we just do something else while we leave our computer on. Sprout Ed is on the cusp of something amazing. And so I'm glad to be a part of it. I hope of the 49 that you are now going to go and watch, hopefully you found this to be the best one, or the best one yet. Again, my name is Bakari Sellers. We're here at the Strom Law Firm in Columbia, South Carolina, where I work and practice. I'm excited. Thank you to the Strom Law Firm for hosting us. I want to wish everyone, I know this is not what you should do with things that are going to be housed, but it's my show, and I am now saying what I want to say. But I want to wish everybody a happy Kwanzaa, happy Hanukkah, Merry Christmas, and an extremely happy and healthy New Year. May your business practice and legal profession bring you great happiness. May you change lives. May you love your neighbors even when they don't love you. And then at the end of the day, as a lawyer, one of the things that I want to do every single day I wake up is change the world. My name is Bakari Sellers. And again, I will end where I began this morning, which is to simply say thank you. Thank you, and God bless you all, and God bless the United States of America.